Recording in progress.
Welcome. Thank you very much for joining us this morning. This is a topic that everyone needs to address at some point in their lives, and it can be difficult. So the ability to join together to talk about this is really valuable because you're not alone. We all have to walk this path at some point together, so thank you very much for joining us. The New Jersey Regional Family Support Planning Council was authorized by an act of our state legislature. What does that mean? That means we have an organizational structure. We have access to people like Kyoko, who you've already met, who, by the way, if you don't know her and you'd like to join this, this group, send her an email. Her email and the other wonderful person we have in our organization, Carrie. Their emails are on the very last page of the presentation. But we do have regular meetings with the state, with the adult population, specifically with Jonathan Seifried, who will be speaking soon. That is a group that I'm very proud to have served on, and mostly because of Jonathan. Jonathan, as the head of DED, has been very, very open to the family voice, which I think is important for any system that deals with people with developmental disabilities. We also have monthly meetings with the state, or bi-monthly meetings with the state on the children's system of care. We also have a committee on health and safety. We wrote a white paper a couple of years ago. We worked with Jonathan and other people at the state to actually affect some of the changes that we recommended. We've recently re-invoked that committee. Many of you probably have read the articles that were published in May by the Record, Hidden at Home. That was very heart-rending. This is something that no family wants to see happen to their person. Okay, so that's recently we also created a legislative committee and a planning committee so we could focus on issues that families think are important. If you think there is a subject that we should be spending more time on, join the planning committee or just send an email to Kyoko or Carrie. Okay, without further ado, Jonathan Seifried, the floor is yours.
Good morning, everyone. Oops, get myself together here. So great to see you all today on this great Saturday. I know it was raining this morning, but it was opening up a bit, coming back with some sun. I know it's going to rain later on today, but things are looking good in terms of weather for at least today and tomorrow. So again, thank you all for having me here for the Passing the Baton Future Planning for individuals with disabilities and their families. I'm better kind of mobile than in one place. Things that I'm going to go over during at least my portion of the agenda today are on the screen. I was asked to cover a myriad of different topics, which is fine. But we're going to go over an overview of division services for people that may not be under services yet, maybe transition into the system. Talk about some communities of practice that the division partners with the DD Council and other state divisions with to help affect some change related to person-centered planning and thinking in the state of New Jersey, and some tools that can help effectuate that. Talk about our Office of Education on Self-Directed Services that I will embarrass Trish Brennan, who's here today. She is my director of that office and does a spectacular job at that. Talk about some other stakeholder meetings that the division has with various partners. Talk about our some current and future projects. And I was adding in an update on our vendor fiscal employer agent fiscal intermediary transition that's going on. That affects individuals that are self-directing services using self-directed employees or goods and services like a gym membership, something like that. And then family and provider relations. Without further ado, Keiko, if you could take us to the next slide. All right, so just to set the stage, and I think Dottie already did a great job of that. But the division, we recognize the importance of meeting the growing needs of individuals with disabilities as they age. And that includes acknowledging that family members, caregivers are aging as well. And that's true not only of the IDD system, but also of really any of the care economy segments of our service system as well, whether it be aging, mental health, addiction services, et cetera. And we also recognize that each family has their own unique lived experience, and that needs to be respected throughout the process. Go to the next slide. All right, so I have several slides on just an overview of services. And if you're already under services, maybe this is old hat, but for people that are younger or transition to the adult system, this is a good overview, I think. So the division, we serve, we fund services and supports for about 29,000 people that will reside in the community throughout the state of New Jersey. Our services are available for individuals who are age 21 and older and meet their eligibility requirements. And to be evaluated for eligibility, a person must apply for services. In addition to having a developmental disability, a person has to have functional limitations in 3 or more life areas. So there is a process to meeting the federal and state criteria for eligibility for services. A note for people that haven't applied yet, that an individual with disability can have a family member or someone else, assist them with the application process, but the application needs to be signed by the individual or their legal guardian if they have one. So that's an important piece. That the individual or their legal representative needs to sign that intake application. And once that application is received, it can take up to 60 days to process. If the application is incomplete or missing information, that process could take longer. So it's just important to have that that complete application in. So we use a standardized assessment at the division to determine eligibility and help support coordinators and providers understand what services are needed. And we call that tool the New Jersey Comprehensive Assessment Tool, or NJCAT. That is a tool that evaluates the need for support in 3 main areas. It looks at self-care, behavioral, and medical. And those results establish ultimately an individual's tier. And that determines an annual budget that's available for them to purchase services with. There are 10 tiers that we use. A through E as in Edward, and each could have an acuity, which is a little a. So A with acuity, B with acuity, so on and so forth. You can go on the next slide. Now, in terms of after you have that NJCAT and all done, I want to talk about how the care management piece works. So the care management and individualized service plan development, that is provided by independent support coordinators, and they are employed by DDD and Medicaid-approved support coordination agencies. Support coordinators are required to, and this is important to know coming into services, at a minimum, through our waiver, to complete a monthly phone contact with the individual or their family member, friend, whoever is helping coordinate services or overseeing. A quarterly face-to-face contact, and that could be at a day program, that could be at their work, that could be at home, and an annual face-to-face home visit. And that would be either at a group home or a supervised apartment if they happen to live in a residential setting, or at the family home. And those are required per our waiver. Now, those home visits don't have to be really long visits. It's really to make sure there's an eyes-on for the individual. And there are accommodations we can make because we do have some individuals with health issues, and there's some concern about being around individuals that are not normally around for long periods of time. So that can be facilitated in a way that they're quick meetings and don't necessarily have to take a lot of energy. So when an individual has completed their division eligibility and found eligible for services, their intake worker with the division will provide them with the support coordination agency selection form. Individuals can choose the support coordination agency they wish to work with. We have a listing on our website that is updated weekly of support coordination agencies. We're going to be updating that in the next month or so. Maybe just a tad longer, but we're updating that to include support coordination agency caseloads, numbers, and number of support coordinators employed and support coordination supervisors. So they can pick one from that list, or they can ask to be auto-assigned, because there's about 140 support coordination agencies in the state. So sometimes people know exactly who they want, and sometimes they do not. So we could do the auto-assignment. Once a support coordination agency has been selected and put it in the system, they will be assigned a support coordinator, the individual will, to help work with the individual and their caregivers, and they'll work to complete that individualized service plan, person-centered planning tool, and any other elements related to the service planning. Okay, so persons that are end up being enrolled on in division services or eligible for division services are enrolled in one of two waiver programs. We operate two federal waiver programs through the Medicaid program, Centers for Medicaid and Medicare Services. Our first waiver is the supports program, the first one I'm going to talk about. And that provides an individual budget to each enrolled participant based on their NJCAT assessment. And it offers services in the domains of employment and day services and family supports. Any person eligible, enrolled in division services is eligible for this waiver, and that it's the base waiver people go on. Now, we also have a second waiver that is called the Community Care Program. About a decade ago, it was called the Community Care Waiver for people that remember that. But it's a Community Care Program at present, and that provides an individual budget based on the NJCAP, very similar to the supports program. You have the domains of employment day supports and family supports, but this waiver includes an additional domain of individual supports, and those are supports utilized to, for lack of a better term, residential. It can be used to fund services in a group home or supervised apartment. It can be used for individual supports for people living in their own home. But that's the main difference between those two waivers is the community care program offers that residential, I'll call it a bucket for individual supports. Now, it's important to note that enrollment onto that community care program is based on a person either coming up on our community care program priority waiting list, or they have been deemed an emergency through the current regulatory structure, which is homeless or imminent peril. Homeless within 30 days or imminent peril. And those are a bit subjective, the imminent peril, to give us some flexibility there. And you have to meet the level of care for that program. The level of care means, and this is within the manuals, but we operate within New Jersey developmental centers as well. Essentially what the level of care means is, but for enrollment on the community care program, the person would need to be admitted to an institution, which we'd look to avoid at all costs. So it's just that additional step there in terms of level of care. Thank you. Okay, and this is just an overview of our services. So I'm not going to go over each of these services in detail right now, but these are the services between both programs. Where there's a parentheses where it says SP only or CCP only, that particular service is only in that waiver. If there's no parentheses next to that, it means that it's available in both waivers. And just because I want to make sure I don't confuse people, PERS over here next to Personal Emergency Response System is just the acronym for that. And that's one of those devices where you could hit to call paramedics if you fall in your home, something like that. Sometimes that is a service that a person can use in lieu of staff. But these are all the services there. We have from assistive technology all the way to vehicle modifications, environmental modifications, and OT, occupational therapy, physical therapy, and speech therapy. And within either of our waiver program manuals, we have very lengthy definitions of each one. And if you want some good material to put you to sleep at night, you can go ahead and grab that and read about each particular service. Okay, Yoko, if you could take us to the next slide. Okay, so we also fund rental subsidies for individuals living in provider-managed settings, and those are group homes or supervised apartments, as well as those renting from private landlords. And what I mean by that is just like you or me, we rent from John's apartment complex. That's what I mean by a private landlord. Individuals who receive a division rental subsidy are required to contribute a certain amount of their income to their rent. That's generally 30% of the income, and if their income's zero, their contribution is zero. It's just 30% of whatever their income is. and they are permitted to rent units up to the published rent standard covered by the subsidy. Those are based on the state of New Jersey's fair market rents. And we have a partnership with the Support Housing Connection over at the Department of Community Affairs that actually administers those rental subsidies. I'm noticing that I'm probably going really long, so I'm going to try to pick it up a bit. So I now want to talk about some communities of practice that we participate in. And I talked about this a bit at the beginning. So the first is the community of practice for supporting families. So this is a partnership that we have with the Boggs Center on Disability and Human Development. And we have Colleen here today from them. And the New Jersey Council of Developmental Disabilities, as well as the division. And we're an active member state in that community of practice. We were accepted as a member state in 2019. And since then, the groups have gotten together and we have put together the following goal for participation in the program. And that is for people with disabilities and families to be empowered to communicate their vision for a good life, and for professionals and systems to ask questions, listen, and act on strategies to help us reach that vision. Next slide. Continuing just a little more information on this community of practice. We began that with a focus on our systems foundation. When we started it back in 2019, 2020, and due to the pandemic, we had to pivot and do some virtual things, but we won't talk about the pandemic again. And that was focusing on the individuals we serve and their families. And that was through educating them on the Charting the Life Course framework. We're very fortunate to be able to leverage the DD Councils, New Jersey DD Councils, regional family support planning councils for that work to help us reach those individuals. We then shifted our education on that framework to state staff with a focus on supervisors and managers. And the purpose of that was that for them to learn about it, but also for them to be able to educate and reinforce these tools with their staff. So that way, as they start hearing more about them from families and individuals using them, they nurture the use of those tools and don't kind of say, well, that's new, I don't know about that, we're not going to pay attention to that. We want to make sure that we're facilitating some change there. And then most recently, the Envisioning the Good Life Through All Life Stages work group was put together, and they focus on different life stages and how a person's hopes and dreams can be met and services wrapped around them at any stage of life. Okay, moving on. Now we have a second community of practice that we participate with as well, and that is Bridging Aging and Disabilities. We're, again, happy to partner with that. This is a grant offered by the National Association on Councils for Developmental Disabilities. And there was a 5-year grant for this community of practice, and it's focused on improving aging services for individuals with intellectual and developmental disabilities, as well as their aging families. That's a partnership that we have, again, with the New Jersey Council on Developmental Disabilities and the Division of Aging Services, as well as our Division of Developmental Disabilities. And the objective of that program, if you could just go back, is making a difference together, build relationships, and coalesce statewide advisory team members around a shared vision of increased understanding of services, breaking down silos, and improved access and service delivery for individuals with IDD who are aging and their families. Okay? Okay, so this year, the community of practice is working to bring the statewide advisory team members together to develop a roadmap to assist individuals in planning throughout their life stages. And additionally, the grant is enabling New Jersey to work with national technical assistance to assist in developing resources and future planning. Okay. I think I'm actually doing okay on time. Okay, thank you. And next I have a slide on the Office of Education on Self-Directed Services. And I will say that this is the only office in the nation that I've been made aware of that is focused on this goal. And that is, we recognize self-direction as being an important and needs to be an option for people. And they need to be aware of that option, because you don't only have to get services through provider-managed group homes. You can self-direct services, and that can be in many ways. You can self-direct by, taking classes, by having a self-directed employee, et cetera. But we recognized when we were, in feedback from families through different forums, that it was a bit of a, I'm embarrassed to say, mystery. People didn't know how to do that. Like, well, what does self-direction mean? And there were pockets of really great information, but it wasn't necessarily readily available in a way that we thought was meaningful for families. So we created this office. And they provide education and training for people with IDD, receiving services, their families, advocates, stakeholders, really anyone interested, who are or are interested in sharing their experience about self-direction or learning about it. Trish's office does not replace a support coordinator, but they are a resource to that. They provide that technical assistance. Okay, can move on. A big part of what Trish does is connecting people with each other, and that is through family networking sessions. She holds those throughout different parts of the state. But for families to get together who either do self-direct or want to know what that's about, to connect them and form those networks. And then we have something akin to that for our peer-to-peer network, individuals with disabilities. So same thing, an individual with a disability who self-directs or wants to learn about it, they can take advantage of these sessions. Okay. Just wanted to go over some regular stakeholder meetings we have. At the division, we have a monthly division update webinar. It's generally the fourth Thursday of every month at 10:30. Sometimes it changes due to the way holidays fall. But fourth Thursday of the month is when we do that. We also meet monthly with Disability Rights New Jersey. We meet monthly with our Family Advisory Council, which are the leads of the Regional Family Support Planning Councils. We meet quarterly along with many other state divisions and department representatives for an interagency disabilities working group. We meet monthly and quarterly with the Council on Developmental Disabilities, Mercedes, et cetera. We have a self-advocate advisory committee that Trish also does a great job with her team that meets quarterly. And we meet with the Boggs Center on Disability Human Development monthly and our trade organizations monthly as well. And those are organizations that represent agencies. Some current and future projects. This is not an exhaustive list. But we have our START program rollout. That is Systemic Therapeutic Assessment, Resources, and Treatment. That has been something we have been working on for years to get off the ground in New Jersey, and we were able to see that through, and the RFP was awarded, contract struck, and we're actually starting a rollout of that now. So that is going to cover the southern half of the state, and if that goes the way we hope it will, we're going to look to expand that to the northern part of the state as well. We have our vendor fiscal employer agent transition. I have some slides on that, so I'm not going to get into that too much. We have a pilot program that we're working on with the National Association for the Dually Diagnosed, and that will provide about 2,500 direct support professionals a certification in dual diagnosis. We have updated our direct support professional training, launched a jobsthatcare.nj.gov website. We are a member of one of a few states that got a technical assistance grant for direct care workforce that we're continuing to work on. And then we have, at the federal level, the Home and Community-Based Services Access Rule. That is a multi-year phased project. And another thing that we're working on moving forward is updated support coordination training. Okay. All right, so now updates on our vendor fiscal intermediary transition. So this is, again, relevant if you or your loved one utilize self-directed employees or goods and services, and that could take many forms. That could be a gym membership, a class, et cetera, paid through our fiscal intermediary. This is only related to our public partnerships contract, not the one with Easter Seals. Easter Seals operates a different fiscal intermediary service called Agency with Choice. I'm not talking about Agency with Choice, so I just don't want people to be confused on that. And my alarm's going off, so I am going to be over time, but I'll try to go through this quickly. So we have updated our guidance related to this, and we have information on our website on it. Actually, why don't we, can you go forward a slide? Okay, so the next slide or the slide after, I'll have links to the website where you can go to. But we have guidance out there for our support coordinators. We're working on the guidance for the individuals and families, but we are doing a transition from public partnerships to Acumen, and that is because the contract, the way procurement works in New Jersey, you have to rebid things every few years, and that's the time we're in now with it. We are doing the transition in cohorts. There's about 9,000 people that receive goods and services, and about 4,000 people that use self-directed employees and possibly goods and services or not. We're focusing on cohorts 1 through 4 now, which are the people that only use goods and services, about 9,000. And we have guidance on our website, but we've condensed our open enrollment window. We used to have a week for each, or was a few weeks. We still have those, but you're able to enroll earlier if it's more convenient for the individual and the support coordinator. But the support coordinators can review this. The most important thing for support coordinators here is they do not need to wait until an individual in their cohort or their authorized representative completes their Acumen enrollment before revising and approving the plan, as long as the plan revision aligns with the timeframes and dates there. An important note with this is we are doing, essentially re-enrolling everyone, all the vendors and all the individuals. We looked at other states when they went through this, and one of the primary issues of challenge was data integrity challenges during the transfer. So we're just doing a re-enrollment. It's a bit more work, but it will make sure that the support coordinator, the self-directed employee and/or their vendors get paid. Otherwise, we have a lot more to go through. Please move to the next slide. Okay, so if you are an individual who participates in that vendor fiscal employer agent self-direction model, and if you don't know what that means, maybe another way to do it is you use PPL. If you're utilizing PPL and they're paying your self-directed employees or they're paying your goods and services as the fiscal intermediary, and you didn't receive or maybe misplaced your cohort assignment notification, please contact Acumen Customer Service and the 833 numbers on your screen, as well as the website address for that, and you email them or call, and they will give you your cohort number and the information and tell you how to move forward. Next slide. And you can go to Acumen's New Jersey website for training materials and information for employers, authorized representatives, self-directed employees, et cetera. And on the division's website, we also have information on the transition that has updates in our transition FAQ. Move on. Okay, and I'm on the last 2 slides. So, this is on family provider relations. One thing that I was asked to kind of talk about are those family and provider relations and how good relationships can start from, can be fostered from the start. So I'm not going to take credit for this. I had actually had the fortunate experience of working with the DD Council and Family Advisory Council, and we worked together on this a few years back. So I'm really, I pulled some information from that. But well, the information that I'll share on that is, stating the obvious, one of the most difficult things that a family can contend with is the reality that at some point in time, they may likely need help, other than outside of the family network to have support to care for their loved one. And those families have provided those care needs for the life of that individual, and they are the experts on everything a caregiver needs to know about how to care for that person. Now, transitions can be emotional and daunting for an individual with a disability as well as their family. And the best outcomes occur when all parties recognize the need for trust and understanding to ensure the individual receives quality care. Creation of a partnership at the beginning promotes open communication and exchange of important information between the individual and family and provider, and helps avoid negative experiences moving forward for all involved. Go to the next slide. Okay, so some suggestions there are to review public-facing information about the service provider. So we have at the Department of Human Services an Office of Program Integrity and Accountability, and they put out quarterly a risk indicator report. And that was updated within the last couple years to be a little more family-friendly, and it uses stars. I think you can have, from 1 star to 3 stars, or maybe it's even 4 stars. 1 star being bad, 4 being bad, and 4 stars being you're not tripping any indicators. But that's a good piece of information. You should, if you're engaging a service provider, ask them about their experience serving individuals with similar needs to your loved one. So if your loved one has medical needs, ask them what's your experience dealing with this XYZ medical need. If it's maybe there's some support they need around behavioral intervention, like what's your support there? Leverage the DD Council, the Regional Family Support Planning Council, as you know, who put together today's event. They have representatives for every county in the state, and it is a great network to talk with other families and individuals to find out their experiences. And when engaging with service providers, just be clear don't make assumptions moving in. Like ask them specifically about, explain the involvement you plan to have or feel you're going to have. With the agency, outline expectations related to medical oversight, information sharing, any areas that are important to the individual guardian or family. And that's so everyone has clear expectations moving forward. And I think there is one more. Oh, that is it. So thank you so much. I'm over time, otherwise I could go on for hours, honestly. But thank you so much. I appreciate all the time, and yeah. Oh, sure.
Okay, there we go. Okay, so we have 3 questions regarding Acumen.
Sure.
If you could just explain really quick what the cohorts are,
Sure.
and like why they're being divided up.
So the cohorts, as I said, we have about, so cohorts 1 through 4 deal with individuals who only use goods and services and no self-directed employees. That's about 9,000 people. They were divided into 4 different cohorts, so they could more easily do their enrollment with Acumen. And that has to do with the vendors as well. So that's why they're put up that way. So we don't have 9,000 people raising their hand like literally at one time. We wanted to make sure Acumen would be able to have the bandwidth with their customer service to be able to handle the people that are coming in.
Sounds good.
Sure.
And then the other question is if you have any goods and services that you're trying to enroll between now and June 30th, can you enroll them? If they're new.
Sure. On our division website, there is a frequently asked questions document. We do have cutoff dates for adding new services, but I don't have it memorized what's a self-directed employee date and what is the goods and services date. The reason why we do that, though, just for clarity, is we don't want people to have to enroll twice. Because if you start the goods and services enrollment process with PPL at a certain point in time, it may not be done in time for your Acumen transition, and then you're just going to have to start over and do it with Acumen. So it's really to try to make the enrollment process a little bit easier. But you can email what's not on the screen. I had the Acumen email address on the screen before. You can email them and they can give you the cohort number. We're also happy, we have a fee-for-service email address I can give to you. Maybe we can put it in the chat. Mm-hmm. But we also will take questions to that email address as well. We recognize the importance of people getting paid on time, vendors getting paid on time. We take it very seriously. We recall the challenges from 2017-ish related to fiscal intermediary, and we don't want to relive that, which is why we're trying to be very methodical with this.
And the last question is, will the application to Acumen for goods and services and self-directed employees be pre-populated with information already given to PPL?
It will not. We are going to do fresh enrollment for everyone, and again, that is because what we found was data integrity challenges when we talked to other states were the prime reason for issues with a fiscal intermediary transition. I actually talked to some states who dealt with the Acumen as well during the transition. So we are moving through and doing a literal re-enrollment for everyone to make sure that everything's accurate.
Sounds good. Thank you. Those are all the questions.
Absolutely. Thank you so much. Appreciate everyone's time.
Thank you, Jonathan. So I neglected to mention that we actually have 40 printed copies for presentation. Obviously, all panelists are very passionate about this topic, so the total number of slides ends up 219 pages. But if you need a physical copy, please come and see Carrie. And next speaker is Gabrielle and Ellen.
Hopefully this is on. Good morning, everybody. My name is Gabrielle Bohon. Is this on? Okay. First, foremost, I'm a parent. I have two beautiful girls. The younger one has Down syndrome. She's 26, and she is working as well as doing some other things in the community. She just got her brown belt in karate, so we're very proud of her for that. I'm also a member of the New Jersey Family Support Planning Council. I serve on several of the committees, including the Children and Youth Committee for New Jersey Council of Developmental Disabilities. I'm co-chair of the Council 1, which covers Morris, Warren, Sussex. And I'm also on the community practice for supporting families. But I'm here today wearing the hat of an attorney. My firm is Falcon Law Group. My focus in the firm is guardianship, supported decision-making, special needs planning, succession planning, wills, trusts. And we're based in North Jersey, but I will talk to anybody, anywhere through the state if you have any kind of questions. And I take a person-centered approach. When I develop a plan for a family, it's for that family using the tools that I know. And this is my friend Ellen.
Thank you. My name is Ellen Nalven. I'm the Executive Director of Planned Lifetime Assistance Network of New Jersey, or Plan NJ. We are a statewide organization, and we serve people with all different kinds of disabilities. We serve about a total of almost 1,000 people in the various services that we offer. And our focus, our mission is to help families answer the question, who will care for my loved one when I'm gone? This is obviously a very challenging question, the question that everyone is here for today, and it's also an extremely individualized question. Every person, as Gabrielle said, needs a person-centered plan. One person does not have the same needs as another. One person does not have the same skills and abilities or supports as another. And so everything that we do is based on what the particular individual needs and what the family has requested. So our focus is life planning first to help people. We encourage you to start with the specialized attorney, and the specialization is so important. If your family kind of says, gee, I can do this, I can write a special needs trust, or I can do a guardianship for you, you may not actually get what is best for your individual. You might get more than they need. And you also might have a situation where it might not be as following the law in the way that it really needs to be, the legal planning. So you start with the expert attorney, and then you come to us for your future planning, ideally. So a lot of folks will write a life plan. We will write a life plan with the family, for the family, and then we can serve as legal guardian, whether it's limited or full guardian, plenary guardian. We also serve as trustee for special needs trusts. So we'll tell you more. We're here to talk with you about those tools and a few others, ABLE accounts and representative payee for Social Security. We take those roles as well, often just as successor to successor. So if you have families who can do this, that's ideal. But we are the backup to those folks in some cases, or we are the next in line for family if there's nobody else. So we look forward to talking with you more about these kinds of tools.
So Ellen and I, as she said, we're going to start with the foundation for your succession plan, the legal and financial things that you have to think about, and then you're going to use that to build the rest of your plan that other people are going to be talking about today. So I'm going to focus in first on your individual, guardianships and supported decision making. So what is a guardianship? It's basically the legal authority to make decisions for another person. A developmental disability or psychiatric illness does not necessarily mean that the person needs a guardian. It depends on their disability and their capacity to manage their own affairs. The court must find that the individual is substantially unable to provide for his or her financial, physical, emotional, medical, and/or residential needs because of a cognitive disability. This is the same standard for anybody who's going to court looking for a guardianship. And the guardianship can be over the person, the property, or both. Now, person is managing the everyday needs, the medical needs, health, and home needs for the person, and then property or estate is managing their money. So you can have one or the other or both. The role of a parent, I'm going to go way back to my civil procedure professor back in law school. He described our rights as a bundle of sticks. So when a child is under the age of 18, we parents are in charge. We are the ones, well, okay, we think we're in charge until they're teenagers. We tell them where to, what to do, take them to the doctors, what their schedule is. We manage everything. But everybody, I mean everybody at 18 turns into a legal adult. And they get their full bundle of sticks, as my law professor called rights, to make decisions for themselves. So that when they turn 18, parents aren't making the decisions for them. And that's why we're going to need either a guardianship or a supported decision-making document. So you have to understand what your child at the age of 18 can handle, what they can do, and what's best. And the best way to do it is talk to them, find out what their needs are, what their dreams are, and work with them. There's a serious impact on an individual's rights when we do a guardianship. So as you think of the bundle of sticks, a guardian will take the whole the bundle and manage the person's day-to-day life, as well as if they have property, over their financial life. And it affects the decisions where they live, manage their bank accounts, ability to enter into contracts, consent to medical decisions. So a role of a guardian is achieving the maximum self-reliance that that individual can do. And as parents, we kind of understand, but we have to look at our loved one as an adult as they're turning 18. There are, next slide, Kyoko. So there's two types of guardians. So the first one is a full guardianship. That's basically taking that whole bundle of sticks, all right? And you're the one making the decisions. A limited guardianship is where you leave some of those responsibilities with the individual, okay? So if you're guardian over the person and not the property, then that individual will manage their own finances and enter into contracts and legal things like that. Even under a person, you can agree that the individual can manage their housing on their own or who they interact on their own, and those are rights that you leave with the individual. It's something that you work with the courts and the individual, what sticks you're taking out of that bundle, okay? Next slide. There are two statutes to get a guardianship. Statute 3, Title 3B. Yeah, now I'm going to get into legalese, I apologize. So Title 3B is the same procedure for anybody going under a guardianship proceeding, okay? It doesn't matter if they have a developmental disability or it's another adult who has a diagnosis of dementia. It basically requires 2 medical affidavits. Either you can use 2 licensed physicians. They can be, New Jersey will allow you to use a physician from another state as long as they are licensed in that state. So if you have a doctor that you go to in Philadelphia or into New York, New Jersey now recognizes them as well as those doctors licensed here in Jersey. The doctors can be from the same practice, but they each have to fill out their own certification. So if you go to Dr. Smith and Dr. Jones is in the practice and they say, oh, I'll do it too, his certification says whatever Dr. Smith said is I agree with. That doesn't count. He has to do his own exam for the individual. And the doctors have to be courts prefer either the primary care physician or general practitioner, a neuropsychiatrist, a neurologist, a licensed clinical psychiatrist, and that psychologist, the licensed clinical psychologist is not the same person as the school district. Those are 2 different licenses. So you can't say, well, they see something in study in school. They must be a licensed clinical psychologist or a psychiatrist. They don't want ophthalmologists. They don't want podiatrists. They want doctors who can speak to the person's cognitive ability. And your first step along this path is to talk to your doctors because they're the ones who are going to give you the certifications. So you need to talk to them ahead of time, before they turn 18. Talk to them whether or not the doctors feel that the individual can manage things on their own and how much is manageable. It is a very quick process, so there's only 30 days allowed. So we're going to take June, even though tomorrow is Sunday. If you go see the doctor on June 1st, you must have the paperwork into the court by June 30th. It is a tight schedule. Courts are not very lenient on moving things. It is calendar days, so holidays also count. So again, you need to move fast. You need to work with your doctors as a team. Once you file your petition, the court will appoint an attorney for your individual. Okay? Many times, the court-appointed attorney is an attorney on a roster for the court, and it is not pro bono, meaning without money. It's somebody that you have to pay in addition to your attorney that you're hired. The money for the court-appointed attorney can come from your individual. So if you need to spend down some money, that's a perfect way of doing it. The court-appointed attorney is somebody, most courts will appoint somebody who has knowledge in this area, but I do know some counties who will appoint anybody. I've had guardianship proceedings. The court-appointed attorney was a real estate attorney. Lovely individual, did not understand anything about our world. So it was, he interviews your family, either on Zoom, in person. When I'm acting as a court-appointed attorney, I'd rather go to the person's house because I want to see where this person is, how the family interacts, if there's brothers and sisters, and plus it makes the individual more at home and more relaxed, talking to a stranger, asking them questions. But some attorneys would like you to go to them. You don't have a choice in a court-appointed attorney. It's just whoever comes up on the lottery first. The court will then hear the papers, review the papers that you submitted from your doctors, and the court-appointed attorney's report. Most courts now, since COVID, do the hearings on Zoom, if they do the hearings at all. Sometimes the courts are very happy with just the paperwork that you handed in, and then they make their decision. It's a yes or no basic decision. Yes, this person needs a guardianship, or no, they don't. The other type of proceeding is the Title 30. Now this is one that the individual has to be enrolled in DDD first. Now if you're talking about an 18-year-old, like Jonathan was saying before, DDD doesn't start until 21. And to get to DDD, you have to qualify, and one of the big qualifications is being eligible for Medicaid. One of the easiest paths to get Medicaid is applying for supplemental security income through the Social Security office. With that, you will get the Medicaid for aged, blind, and disabled. But as we all know, there's now staffing shortages throughout the government. It was never a fast process to start off with, so it's going to take a while for it. This is why we use the Title 30 most of the time, because it's faster, because parents get a little bit scared about an 18-year-old not having a guardian until they turn 21 or so. The difference also is that you only need one licensed physician or clinical psychologist, and then it gets a little bit easier. You need a certification from the school district personnel with a copy of the latest IEP. That could be the case manager or even the secretary of the special services office. Or you can use a person who has knowledge of the functional capacity of your individual. That could be the behaviorist. A statement from the administrator from a DDD program that they're in, if they're already enrolled in DDD and receiving services. That could be somebody from the day program they go to, or it could be somebody from one of their other services. It can be also another physician or psychologist, just like a Title 30 proceeding. And the last option is a licensed care professional, which can simply be the RN who comes in to take care of your child at night. The petition has to be filed within 180 days, 6 months from that first doctor's appointment. Okay, so it gives you a little bit of extra time because it's a little bit more going through the different hurdles in order to qualify for DDD. No offense, Jonathan, but it's a little bit tough. I'm going to take a sidestep here because I want to talk about the schools. A lot of nonprofits use this Title 30 because it's been around longer and it's a little bit more common than using the Title 3B. A lot of times school districts look at you and say, first off, you're entitled to a triennial exam. A triennial exam from the district is every 3 years they reevaluate your child for special education services. You're entitled to that, triennial. I know of a lot of school districts that just say, well, we know Junior, he's a wonderful student. We don't need to do the triennial because we know them. The problem with that is those reports are going to be too old. The educational report, the psychology report, even the behaviors report from the school is too old if it's done last time it was done when the kids started high school. We want it sooner. It's better for the most recent reports. So when this district tells you, we know Junior, that's nice. I'm so glad. But I'm going to apply for Social Security, DDD, Division of Vocational Rehabilitation Services. I need something more current so that these strangers know how wonderful Junior is, okay? So don't be afraid. And the other thing I want to let you know is that before your child leaves the school district, if you should apply to DDD to get things started a little bit earlier and select your support coordinator. You can ask your support coordinator to come to the exit interview for your child's last IEP, and every child's entitled to that exit interview. This is starting passing the baton because they have been with your child for 15 years, basically, if you're staying in the same district. It's very nice for the support coordinator to understand what services that child was receiving rather than just going through an IEP. So just remember, the school district is also your partner. You also have rights within the district. And if you have any questions, there are advocates out there to help you with this, and there are also special ed attorneys. I am not a special ed attorney. I'm talking to you as one parent to another who insisted my district do these things for my daughter before she left. So then the next is the order from the court. These are the standard requirements of a guardian when they go through the report of an order being granted. And I'm highlighting them so that families understand what they are. First, you have to ascertain and consider the characteristics of the ward. That's what we call a guardian, again, legalese. Their uniqueness and their individuality. So that underscores person-centeredness. You have to encourage the individual to express their preferences and participate in the decision-making as much as they can. Person-centered. You have to give appropriate deferences to their expressed wishes. Protect them, of course, from injury, exploitation, undue influence, and abuse. Promote the ward's right to privacy and dignity, self-determination, and respect. Make reasonable efforts to maximize their opportunities and individual skills to enhance their self-direction. Make annual reports to the court based on whether you're guardian of the person or the property or both. They are required, and you do it on the anniversary that you received the guardianship. And you must make regular visits with the individual. Now, family members usually do that, but as Ellen will explain, her agency can also do those kind of things. So now we're going to move on to supported decision making. Okay. There are 27 states, plus the District of Columbia, that have passed laws about supported decision making. Of these, only 21 and DC have laws supporting a supported decision-making agreement as a legal, valid document. New Jersey is not one of them. But we do recognize other documents. There has not been a bill submitted. There has not been any committee talk on this. So we turn to the other documents that are normally recognized. Next slide. Okay, so what is supported decision making? It's basically having somebody, again, working with them, helping, encouraging them to make decisions, helping them choose who's part of their circle, helping them decide on who their support people are. Basically, supported decision making is something that every one of us does every day. Okay? When you go and ask your friend to go to the doctor's office just to have a second set of ears when he's telling you something, that's supported decision making. When you ask somebody, I'm rethinking painting this room, what do you think? That's supported decision making. Okay? We all use it every day. Every time we turn to our partner, our friends, a colleague, what do you think? So that is basically supported decision making. Next slide. Okay, so the supported decision-making documents are basically that are used. Financial power of attorney, healthcare directive, psych directive, representative payee for Social Security, a trustee for a special needs trust, or a supported decision-making agreement. Ellen's going to get more into, of course, the trust and the representative payee. Next slide. Okay, financial power of attorney, durable financial power of attorney. Durable means that it exists until you have the ability to revoke it. It basically says, I'm picking this person to manage my finances if I can't manage them on my own. Okay, it doesn't mean that you've given up that right altogether. It just means that somebody else can do it. A little story about my older daughter that I usually use to embarrass her. First year of college, well, okay, I'm the parent who would not drive her down to college until she signed a power of attorney and a healthcare proxy, and I'll talk about the proxy in a minute. So I don't want to, I'm not driving you until you do. So yes, a little coercion, I got those documents. The first semester, she's going out over winter break with friends out into San Francisco. Remember to put money in your account before you go. Yeah, Mom, I know what I'm doing. So I get a phone call about 5 o'clock in the morning as she's waiting for her flight from LaGuardia. They won't take my card at Starbucks. Well, did you put money in the account? Yeah, right before I left. That was probably about 3 o'clock in the morning. Trying to explain to her that now her account is overdrawn. First thing in the morning, I have to go to the bank, use the power of attorney to get that all straightened out so that she doesn't get overdrafts and have the money immediately transferred into her account, okay? Second semester with the healthcare proxy, she calls me up. She was very sick. She said she went to the college clinic. She doesn't remember anything they said. Can she come home? I said, yes. Let me call the clinic and find out what was going on. Called the clinic, can't talk to you. She's over 18. So I said, what's your fax number? I faxed down my healthcare proxy, picked up the phone again and said, hi, now you can talk to me, okay? So these documents any of us can use, whether it is somebody who is neurotypical or somebody who has some disabilities, okay? So basically, as you can see, it's the power of attorney can be revoked at any time. That's a little bit scary with some of our folks who can be influenced. But yet they can use that, and that you can use it in any situation. Next slide. The next slide is on the advanced directives. So as I said, the healthcare directive, there's two main parts of it. One is the healthcare proxy. That's what I used for my daughter. That was basically saying, I have the right to access her medical records. I'm the one that when she can't talk, I can talk for her. So that basically addresses the HIPAA and privacy considerations. The other part is the living will part of it, the end-of-life decisions. Most of us are not going to talk to our 18-year-old about end-of-life decisions, but when you do this for yourself, you can consider that. Do you want feeding tubes? Do you want CPR? Most everybody wants the drugs, so don't worry about that. The other one is the psychiatric directive, okay? The psychiatric directive is if your individual is dual diagnosed with psychiatric illness, all right? It basically is created by the individual, and what's good about this is it lists their triggers. It describes what helps them calm down. It describes what doctors they want to reach, other people that they want who helps them calm down. It helps them what treatments that they might agree to. It also helps pick the hospitals. I don't want to ever go to that hospital again. This is where I want to go instead, all right? So it's also the New Jersey Division of Mental Health and Addiction Services, DMAS, contracted with the U.S. Living Will Registry to manage our voluntarily psychiatric advanced directive registry. It's private, it's there so that if you don't have to carry it around with you, if something's going on, you can have a card and just have somebody reach out to them for that. The police do not have access to this registry, so it's very important that if you have a person with triggers, you get to know your local police department. You get to know them, you talk to them, you bring your individual in, and then when something is going on, you can tell them that if you have somebody who wanders, he wandered off again, can you help me? You can give them a copy of the psychiatric directive if you want, and that might help prevent a tragedy from happening, from a misunderstanding because your individual is in a crisis at that moment. So now I'm going to talk about us, and I think I'm taking up some of Ellen's time. So again, the supported decision agreement, you usually list the names of the supporters, their roles, what assistance that you want, provides access to medical information if you want, direct supporters to work together. So if it's really important for your individual to go to that deli on Saturday morning to get their favorite bagel, you can put that into it as well. I do have a website up here for model agreements where other organizations have, but remember, New Jersey does not recognize the supported decision-making as a legal document. They recognize power of attorneys, the healthcare directives, and the psych directives. Next slide. Okay, now I'm going to talk about us. Everybody should have a will, all right? Very basically, a will says what happens to your assets when you pass away. The three main people in a will are the executor, that's the person who gathers up all your information, pays out your debts, and then pays out your estate to your individuals, your beneficiaries. It can contain a trustee if you have a trustee in your as part of your estate plan. It has names a guardian. Now, a guardian, remember, is also somebody under the age of 18. So if you have a young child, you should name a guardian because this is the person who's going to take care of your individual. Or if you were appointed guardian for somebody over 18, you can name a successor as part of your will. And then, of course, the beneficiaries who are going to receive it. Now, I know a lot of people tell me, oh, if I write a will, it means I'm going to die tomorrow. I'm not going to do it. It's horrible. I have to tell you, if you have a child with a developmental disability, you must have a will. Because if you don't have a will, New Jersey intestacy statutes will be very happy to decide who gets what, who's in charge of your child, who is managing your estate, and all the hard work that you've done to set up your child for services, well, now they're going to get a third of your estate, a half of your estate, and now all your work was for nothing. You really do need a will. So please, at least take that away, and you can look at your will. You wrote it when your child was 3 years old, and now they're 33. Please take it out. Please look at it. Make sure it's what you want today. You can modify your will. I say look at it every 5 to 3 years, especially if something big happens in your life, okay? The next slide. The next thing is the standby guardianship designation. It's a new document that New Jersey recognizes. It allows, if you have a child, a minor, somebody under 18, if you're away, if you finally take that dream vacation with your partner, I don't know, I think Antarctica is now the hottest thing to go to. I don't know why. But if you have that dream vacation and you can't be reached by phone, this allows somebody to step in to manage things. Think of it as a permission slip, basically. So if you have a younger child, you should have this. If you have an older child who you have guardianship over, you should have this, because it allows somebody to step in for you. It's temporary. You can use it over and over again. So if you decide to go on the exotic vacations every year, you can give this to the person to manage. But if the person is using it for 6 months consecutive because you've been disabled or you've passed away, they will have to go to court to be appointed as guardian. So you can use it as many times as you want, but if it's 6 months in a row, you're going to have to get appointed after that point. But it's good because it allows that if you do pass away, it allows time to get your estate in order and get somebody appointed. In the meantime, your loved one's still being taken care of during that period. My last slide. Okay, the alternative is, if you don't want to do that, you can be appointed. You can go to court and amend your guardianship order and have somebody appointed with you as guardian, as a co-guardian on that. They're going to have to do the same kind of background check and go through a proceeding and all of that, but it's a way. So if you are guardians of your loved one, you and your partner, and then one of these siblings want to be added, you can do that as well. And that would be automatic when you pass away, that person will now be the guardian for your individual. So now I'm going to turn it over to Ellen to talk about trusts.
Thank you. So this is a lot of information. It's pretty legally intensive. It's a lot of detail. So I kind of wanted to just mention sort of step by step, because a lot of people who come to talk with us at Plan New Jersey to get some ideas of what do I do first, and do I need a guardian? What type of guardian can I do with a limited guardian? Can I do with a power of attorney? These are a lot of decisions. So first of all, we always suggest that you go get your legal documents done first and go to an expert attorney. Do not, sometimes family members, they tell us, oh yeah, my family attorney says I can do that. I can develop a special needs trust document, and they are not up on the very complex laws, and that document could actually cause the person to lose their Medicaid. So expert attorney is very important. The other thing is that, so once you've got your legal documents, the next step is a person-centered plan. And you're in luck, this afternoon, there is a topic on that. There is a whole session on writing a person-centered plan. So that's a really, really important thing. And you can just start with writing down the basic details about your loved one. What's important to them, what's important for them, and we often think about, okay, I know I need to write the medical stuff, but maybe I don't think about what things frighten her, what things help her feel more calm. Those, we want to go into the details, and not just she likes movies, but what kinds of movies. So a plan as well as your legal documents are really critical. The other thing I wanted to suggest is that you make these decisions in chunks. You don't have to make every decision all at once. So take your time, write your plan, but also revise that plan at minimum once a year. And I'd say give it to your child as a birthday present. You're not literally giving it to them. You are revising it, thinking about their birthday as a reminder. Oh, let me update that. Let me write down what changed. The other thing I wanted to say before I talk about special needs trusts and ABLE accounts and representative payee for Social Security benefits, before I forget, I want to tell you that we have some podcasts on our website, and they are available wherever you get your podcasts. Our website is plannj.org, and we have a podcast about guardianship, alternatives to guardianship, and supported decision making. So if you want to dive into the weeds on that topic and understand more, that's there. We also have a podcast on special needs trusts. So I'm about to talk to you some, high-level special needs trust information, but that is there if you want to get into some of the more common questions and myths about special needs trusts. We have a session on housing and supportive housing. We have a mental health episode. So the podcasts, if you listen to them, are a nice way to get sort of in-depth information. So we can go to, actually, if you can go back one. So we're talking with you about a lot of different tools. It's kind of it is a mishmash depending on what's good for your son or daughter. We can use special needs trusts. We can use ABLE accounts. We can use representative payee for Social Security benefits. All of that is kind of intermingled with what is your income? Are you working? Where can the money go for work? And where are your what government benefits do you need? As Jonathan mentioned, critical to DDD, access to DDD, is Medicaid eligibility. So that is kind of really priority, is accessing it and keeping it. So, there's a lot of talk about the fear of what might change in the government with the changes in access to Medicaid. It's really important that you pay attention and advocate for what your son or daughter needs and make sure that stays available. So now we can move to special needs trusts. So special needs trust, I like to describe as an empty cup. It's a legal document. It is written by an expert attorney, but it is usually, I don't know whether you advise your families to fund a trust early, or is it something that they fund later in life?
It depends on the situation for the family, what assets that they have at that moment, but I do recommend that they do not make it part of their will, because you can't access it until you pass away. So if you leave it outside your will, you can make it as a beneficiary to different accounts, life insurance and things like that.
Okay, thank you. That's really helpful. So a special needs trust, it basically allows your loved one to have assets while still preserving those means-tested benefits, SSI, Medicaid, housing choice vouchers, whatever, housing vouchers, SNAP benefits, all of those means-tested, how much money do you have? So I'm sure all of you know that the magic number is $2,000, that a person can have assets in no more than $2,000, and you literally at 2001, if Medicaid does your redetermination annually, if you have $2,001, you can spend it down, and if you spend it down in a month, it's fine. Your Medicaid will stay intact, but 2001 and you are over the limit. Same thing with SSI, Supplemental Security Income and Social Security. So there are a couple of tools, and I'm going to talk after Special Needs Trust. I'll talk a little bit about ABLE accounts. Now that we have those are very helpful in not having to go through the complexity of a special needs trust. So it is complex. Do you put it in your will? Do you not put it in your will? What are the rules? How do you maintain? How does that stay as a tool that both preserves public benefits, but also improves quality of life? So that's what it's for. I have a loved one, I want to leave money for her, she's Medicaid eligible, she must have that. There's no way I could afford all of the services that keep her healthy and well, and so I'm going to put my inheritance money, whatever it might be, into a special needs trust. That could be a lot of money or a little bit of money. Anything over $2,000. Can go into a special needs trust, and you will not affect a person's benefits. So those benefits are considered exempt from Medicaid or SSI saying, oh no, you've got money, you're no longer eligible. So you can purchase a variety of goods with a special needs trust. There's many, many things that can be purchased. Vacations, computers, education, transportation. We have bought houses, we have bought cars, car repairs, books, furniture, clothing. It's a pretty broad spectrum of things. And the other thing a special needs trust does is there's money in an account. It must be administered by a trustee. This is not a court, sometimes it's court appointed, but in general it's just somebody you've named in your will. So it might be you, it might be your son or daughter, and some people will use Plan New Jersey as a successor to your successor. So we're there as in the background should your trustee say, I don't want to do this, which fairly often that happens, especially with siblings. They want to be a sibling, not manage the person's money. It also protects the person from exploitation. So no one can touch the funds, and the funds can't be used for anyone other than the beneficiary, the person you've intended. So that's really important. We can go to the next slide. So sort of the real basic important information to know is whose money went into this trust. So the third-party trust is what we're here encouraging you to do, which is to put your money into what's called a third-party trust, a trust that's been written by an expert attorney. The money doesn't necessarily go in now. It goes in. You're stating in your will that you want your loved one's portion to go into that trust. So it may not be until after you die, but it may be that, as Gabrielle mentions, Maybe there's some money that you want to put in before you die, you want for the person, and you can put that in if it's outside the will. Anyone can put money, a parent, a grandparent, a friend can put money into a third-party special needs trust. So the reason that, and then that money is available to enhance the quality of life of your loved one. So there are things, yes, Medicaid is a crucial benefit to have, but if I need a wheelchair, the quality of the wheelchair that Medicaid is going to buy, it's going to fall apart in 6 months. So I probably want, if I have the good fortune to have additional money to buy a better quality and upgrade that wheelchair, I'm going to do it. We have a lot more flexibility. As you know, it's really hard to find a Medicaid dentist. Very hard. And if you can find it, they're not going to see you for a long time. Well, if you've got a toothache, you don't want to wait. All we have to do is justify and document that it's going to be 6 weeks and this person's in pain now, and we can use the trust. A lot of different reasons to use the trust. The other thing that I want to mention is that there are a couple of myths around special needs trusts. One of them is, we've sort of dispelled this already, a trust, oh, that's only for rich people. No, actually, it's for anybody that needs to have money more than $2,000. So it's a really crucial document and tool. But the other myth is that I don't want to use a trust because Medicaid is going to get my money after the person dies. Well, that is absolutely not true. If you do your planning and it is a third-party trust, it was never money that belonged to your loved one, therefore Medicaid cannot touch it. It does have to be administered properly. So you want your trustee to really understand the rules, because they could, if they use it wrong, then there could be some consequences. So they must know what the rules are and stay current with the rules. So that's a third-party trust. The money never was your child's, even an inheritance. So this is why you're here, learning about the critical nature of wills. And so you're going to do a will, and you're going to leave your portion to a special needs, to your portion for your child that has a disability to the trust and not directly to them. It's a pretty simple thing. Now, suppose you don't plan. You don't have a will, and your money, and or you have a will, but you didn't consult an expert attorney, and it just says 50-50 to my 2 children. Well, that child with a disability who's on SSI and Medicaid, are they going to lose those benefits? Well, if you do nothing, yes, because they're going to get the $20,000 that you're leaving for them, and they're going to lose benefits until you either spend down the money, which is kind of a shame. That probably wasn't what you intended for your hard-earned, hard-saved money. You don't want them to spend it down. You want it for those little extras that the person might have wanted. But it can go into what's called a first-party trust. So if, in fact, there's a direct inheritance, you didn't plan, or there's a car accident, the money does belong to the individual. It's called the beneficiary. And so it can be put into a first-party trust, and that money can be used similarly to the way that we use it that I described. We can buy very similar things. There are more restrictions, and the trustee has to be especially knowledgeable because it can be used improperly, and then that can cause the person to lose their benefits. Also, the main thing is that that money is owed to whatever's left when the person passes away. Rightfully so, Medicaid gets to claim it. So at the end of a person's life, we have we have 600 active trusts, and a good portion of them are Medicaid payback trusts, first-party trusts. So the first thing we have to do when somebody passes away is contact Medicaid. They will tell us how much. They keep an accounting. They have an exact amount of money. You were hospitalized on this day. We paid this much for your medical benefits. We paid this much for your prescription drugs. They send us an accounting We check with family, make sure the accounting looks accurate, and then we have to pay that money back to Medicaid. So there is a Medicaid payback provision for the first party trust, but not for the third party trust. So we want to just dispel that myth, because we want to encourage you to have an attorney write this trust for you, so that all the money you saved is used for your purposes. We can go to the next slide. I do want to mention a pooled trust. So a pooled trust is a special needs trust. Can only be operated by a nonprofit organization. Plan New Jersey is a nonprofit. We have a pooled trust. It's called the Plan New Jersey Community Trust. And basically it is a large trust, but it has multiple sub-accounts. I think we have about 300 people who have sub-accounts in the pooled trust. And so it's just the same as the trust that an attorney might write for you. It was written by Herb Hinkle. Anybody remember Herb Hinkle? Herb Hinkle wrote the trust, and it's been updated by another expert attorney, Tom Begley Jr., and it's approved by Social Security, so it's completely legitimate, and it's going to do everything it's supposed to do. The sub-accounts are third party or first party. That's helpful to know. So, if you, a family can plan for a third party trust, or it can be a first party where there is a payback to Medicaid. So the advantage of a pooled trust, again, we want you to consult with an attorney to decide if you should use the pooled trust. For us, simplicity of management, simplicity of investment. One of the things is, if it's a very small trust, our minimum is $25,000 in the pooled trust. Well, that isn't going to earn a lot of money investment-wise. But the whole pool has millions in it, and so then you earn a portion of the whole pool. That amount of money does earn money when it's invested. So combining a lot of small accounts results in more investment opportunities. So that is the pooled trust, and I just wanted to, one of the reasons that family use that is sometimes families say, well, I don't think I'm going to have any money, or it's going to be a really small amount of money. Right now I can't invest in having a private attorney write this trust for me and do all this other stuff. So you can just sign up. It doesn't cost anything to sign up for the pooled trust. In fact, it doesn't cost anything to consult with us on anything. We do charge for guardianship services and trustee services, but that's when there is an active service involved. So we're happy to talk with you and help you weigh and understand what is going on, what might be best for your child. So I just want to give you some examples of trust distributions. As I mentioned, there are a lot of different things that we can use. Medicaid only offers a certain number of physical therapy sessions or occupational therapy sessions. So we can buy more of those. We pay for a lot of pet therapy, music therapy, those things that are really big enhancements, especially for folks that may really need additional services, supports, and things to enhance their life and well-being. So let's move on to ABLE accounts. This was a really, really important law established in 2014 called the Achieving a Better Life Experience Act of 2014. There are several reasons that this is a really great tool. First of all, a total of $19,000 can be placed in an ABLE account every year. So let's say there's an inheritance of $10,000, nobody planned for it. Rather than going through the expense and trouble and sort of complexity of opening a special needs trust, it can go into an ABLE account. So the ABLE account, so the other thing that I love about an ABLE account is that it gives the individual control of their money. So we have a slide on pros and cons of special needs trusts and ABLE accounts. And one of the challenges of a special needs trust, so important, it gives us so much access that we couldn't otherwise have, to public benefits, but it must be controlled by a trustee. That's one of the big rules, is you have to have somebody else making decisions, and it's totally their discretion. So you have to sort of negotiate with the trustee. I need this. Why do you need it? Well, here's the, sometimes without a lot of information, we can, a trustee might not make the decision that the person feels they want. We had a relatively small, I think the person got a trust, an inheritance of $40,000, and he loves to buy guitars, and he wanted us to buy $3,000 to $6,000 guitars, and he wanted to buy one and then another and then another, and we had to explain, gee, your dad really wanted you to have this money for other things besides guitars, and so we negotiated and we buy him a nice guitar once a year on his birthday, and sometimes we get him to trade in other ones, so we get some more bang for that buck. So an ABLE account gives the it's owned by the individual, so they have more control. So money skills are not all or nothing, right? We learn them over our lifetime. And so it's a great tool for helping somebody learn to budget. Gee, they're really not very good with money. The money goes out the window. And so, you know what? I'm going to give you, $100 a month or $100 a week or whatever it is. And with that, let's agree. With an ABLE account, you can buy food. And actually, with a special needs trust now, Social Security used to not allow somebody on SSI, you couldn't receive food or money for food. Now we can do that. That's a very recent, it was a year ago that they changed the rule, and now we can purchase food for somebody on SSI out of a special needs trust, which is just a big relief because, SSI, we'll talk about it a little later, but it's a very small amount of money. It's just under $1,000 a month. And that's for food, clothing, and shelter. And so we need to be able to, if somebody's run out of money, we need to be able to buy them some food. So we're relieved to have a little loosening of those rules. So the person has a credit card, a debit card. The money can be is invested. You can move to the next slide. So it can have a maximum of, back up one slide, please. There you go. One forward. Did we lose the slide? Okay. The account can have up to $100,000 in it. So a person can work and put their money into the ABLE account and not have to worry about losing their SSI. And up to $100,000, at $100,000, remember, at $19,000 a year, it tends to go up every year, about $1,000 a month. But up to $100,000, your SSI check, your cash benefit will stop, but your Medicaid will continue. And so that's a huge, knowing the crucial aspect and importance of Medicaid benefits, that's a huge benefit of ABLE accounts. And as I say, the other thing, while ABLE accounts are a wonderful tool, you have to have had a disability diagnosis prior to the age of 26. So we have a lot of people with mental illness who could really use an ABLE account, but they can't, that we don't have that documentation to prove that they had the disability. And so, but in January of 2026, the age goes up to 46. So that that'll be available as a tool to many more people. So the Social Security definition of disability is what's used to determine who is eligible for an ABLE account. And then the other part of this is, you can go forward one more time. Yes, there we go. Qualified disability expenses are the term that's used for the purchases that are made. And so those can be services for the person or services or supplies, goods. So they can buy food with ABLE accounts. They can purchase somebody to help them manage their finances, somebody who will help them with their banking, or the kinds of support, extra physical therapies, those kinds of things. Now, the one important aspect of an ABLE account that's important to know is that does have a payback to Medicaid. Not since birth, but since the ABLE account was set up. So I know that some families will restrict how much money they put into the ABLE account. So some families will just use it as a savings account for their loved one and put money in up to $19,000 a year, and then they have the flexibility to use it. You can pay your rent out of this. We can, by the way, put money from a special needs trust into an ABLE account, and we do that for a number of people, because if I put it in for rent, if it's paid out of an ABLE account, it has no effect on the person's SSI benefits. But if I pay rent directly from a special needs trust, it can affect their SSI benefits. So that's a wonderful tool to just say, okay, rent comes out of special needs trust into ABLE account, pay the bill. You have to pay the rent within the same month, but that's a way to really manage the all the different ways we have to manage and retain the public benefits that are so essential to our loved ones' care, that are so essential to their health and well-being, and that they have the right and deserve to have. So we can go to the next slide. This is a little more about qualified disability expenses. They are similar to a special needs trust. They're used to, not intended to replace government benefits. So if you can buy something with your Medicaid, if you can pay for your prescription drugs with your Medicaid, you should do that, and save the money in the ABLE account for other things. So the intent of the funds for an ABLE account are to pay for health, supplement independent living, and quality of life, similar to a special needs trust. I'm going to turn it over to Gabrielle to talk about the Able to Work Act.
Okay, Ellen touched on this. So the Able to Work Act was part of the 2017 Tax Cuts and Jobs account. As Ellen mentioned, you could put some of your earnings into the ABLE account, but what the Able to Work Act said was that as long as your employer does not have contribute to our 401k or one of those type of defined contribution plans on your behalf, you can, somebody who has an ABLE account can contribute their salary into the ABLE account. Now, there is a limit. So this is going to be, the account holder's gross income for the taxable year can be contributed, or the current year's contribution limit can be contributed, whatever's less, legalese. So what that basically means is that if your individual is earning $15,000 a year, they can contribute the $15,000 from their salary plus the $19,000 annual contribute. So now they can put up to $34,000 into their ABLE account. If they're earning, let's say, $25,000 a year, they can only contribute the $19,000 from their earnings and $19,000 from the contribution for $38,000 going in. It allows them to save a little bit more money, but it's still, they have to adhere to that $100,000 limit for the capital gains and you have the same limits on what you can use the money for. But it allows somebody to help spend down money for them so that they stay eligible for the Medicaid benefits. Now, these provisions were going to expire when the 2017 tax cuts were going to be expired. So the what was introduced to the Senate, U.S. Senate, was a bill called an ABLE Act. Congress loves acronyms, right? And that was to extend certain things for people who had ABLE accounts. One was to encourage the Able to Work Act to continue, but the other ones were a saver's credit. So if the individual has to pay income taxes, they got a $1,000 credit off their income taxes for contributing to an ABLE account. It's non-refundable, so if your taxes are less than $1,000, you only got the amount that you had to pay, okay? So that was a nice little benefit for individuals. The other one, which is very important because I hear this a lot in my practice, somebody opened up a 529 college savings account when the baby was born. 529 accounts are an accountable resource against Medicaid Social Security benefits. So you were allowed under the Able to Work and ABLE Act to roll that money into the ABLE account, and there should not be penalties for rolling it over for that. So then the ABLE Act was introduced in 2024. It passed the U.S. Senate. It just got reintroduced in February 2025 for consideration. It was rolled into that big, beautiful bill that is going through right now. One ray of sunshine in the whole bill. So hopefully it doesn't get cut out of it, because these are important tools for our loved ones to live a full life. It's a good way for them to save. They want our children to work. It's a good way that not to penalize them for working. So.
Is there any amount of, is it the same limit, the $19,000, in terms of rolling over a 529 plan?
Yes, there is still a limit to be rolled over into a 529. So if the 529 has, $50,000 in it, you're going to have to, like I said, the same rules account for it, but it's at least something to help for it. Because you have the other options with the 529. You can give it to a sibling or a parent or something like that, a cousin, in order to get the money out of them. And really, you should start looking at your child's finances, talk to family members about who named your child to what well before they turn 18 years old.
Thank you. How much time do we have left? Are we okay?
42 minutes.
Oh, my goodness.
Plenty of time. Okay. Hope you have a lot of questions.
I'm sorry.
Okay, that's better.
Okay.
You're tired of us talking, so.
I'm sorry, can I just ask a quick question? Terry, how many questions do we have?
About 14.
Okay, so
Oh,
just not
okay.
allow time for that.
Okay, great. So we've talked a lot about the pros and cons of special needs trusts versus ABLE accounts. Some of the key of the ABLE account is it gives your individual control over their money and allows them to exceed the $2,000 in savings. That is critical. If a person drives a car and it breaks down, it's going to cost more than $2,000. You can almost guarantee it. So, however, so a special needs trust, though, allows any amount of money. You can put in a variety of investment tools. We have, you can hold a house in a trust. You can hold a car in a trust. You can hold a variety of instruments, whereas an ABLE account is only cash. And we can just move on for a minute. You're probably familiar with the let's move to the next. There we go. So, some of the two critical benefits: supplemental security income and Medicaid. So SSI is it's $967 a month at this point for food, clothing, and shelter. Good luck finding an apartment for that amount of money, no less still having money for food and shampoo and clothing and that kind of thing, which is why we're trying to urge everyone to plan ahead for these financial and quality of life issues. It's just, you can't really survive. It's poverty level survival. And then I'm sure you're familiar with Medicaid, but it's so important there are many different Medicaid programs. I was sitting on a plane with somebody, and he was an engineer, and he mentioned that he had some hard luck and was on Medicaid, and we were talking about what are the threats to Medicaid, and clearly the Medicaid that he had been eligible for was the ACA Medicaid, the Obamacare Medicaid, and not the Medicaid that our children are necessarily eligible for. And there are multiple different types, a lot of different income requirements, so it's complex. Even the Medicaid system is very complex in terms of the types of services that are available. But basically they are, physician services. The Medicaid does allow for home and community-based services, if that gets retained. And that's what funds the group homes, and which are, very expensive and very crucial for our loved ones. Let's move on to Social Security representative payee. So in this case, Social Security appoints a person to serve as the individual's representative payee. One important thing to know, a relatively recent rule, is that the individual themselves can request a particular payee. That didn't used to be the case. So you'll get a notice from Social Security saying, the person, and just so you can know, so if you if the person, or if you're suggesting that the person's nephew or aunt should be the rep payee, you can make that request of Social Security, but the bottom line is it is their final decision. So a representative payee receives the monies from the person. It goes in, the money should never be commingled. Same thing with a special needs trust or any of these accounts. Never commingle the person's money with your money. That creates problems that are hard to undo if they can be. So representative payee, the representative payee must account for everything that's spent, keep careful documentation. They are reviewed, they are audited by Social Security, but it can make a huge difference. We have been appointed rep payee by the courts in several cases because a person was going to be evicted because they didn't pay their rent, when simply if they had a rep payee to pay the rent, and the eviction was dismissed, so because they were given a rep payee. So it can make a difference. So this is really a form of supported decision making. The person can they can make their own healthcare decisions and housing decisions and school decisions, but managing money is not so easy for them. So this is an important tool. And we have a quick summary of the services available. Gabrielle, you want to just review the things, your specialties?
So we handle the guardianship, supported decision-making, wills and the trusts that Ellen was speaking of, special needs planning and succession planning. Will help you with coming up with the plan, but it's best to reach out to an organization like Plan New Jersey, who can work with you going through all the steps on things. And then your services?
Yeah, so one of the key things that families come to us for is just help with this planning, help with these decisions. Families that do want our services in the future, and hopefully it's long-term future, could be decades, do have us write a life plan with them and for them. That's a very important key. Even if we are successor to the successor to the successor, sometimes you might have a family member sometimes families will say to us, oh, I don't want to appoint his sister as guardian because I don't want to burden her. Well, if your sister knows that we can guide her, we can help her, she gets that scary letter from DDD, we can help them to understand what it is. Sorry, it's true. So very often and you all, here you are, you're educating yourselves on a Saturday, and you probably are extremely knowledgeable about all these very complex concepts. Well, if they have somebody that they can call to say, what does this mean? We can assist in many ways. So a lot of times we're just the eyes and the ears for family members. So we do a service called home visit monitoring. So there might be a sibling who cares a lot, loves your loved one, but they live out of state or they're busy with their own family. So we will visit on a regular basis and then report back to the family member. Oh, they sound good, or he doesn't sound good, please go visit. He's in the hospital, go see him in the hospital. So, and I just want to I meant to reinforce something you Gabrielle said, was about standby guardianship. That is such a good point. When I read that, I was like, oh yeah, we should remember to talk to families about that, because so many families also say, well, I'm so worried about the gap. If something happens to me and the court takes a while for the court to appoint a guardian, that standby guardian tool is really an excellent suggestion. So thanks for that, and we'll open it up to questions.
Do you point out that guardianship doesn't cross state lines? Because that's something that I just discovered, and we have a lot of people wanting to... I'm sorry. Oh,
You have to...
Oh, sorry. You can repeat
but
the question.
no, your question was, and I was going to mention that. Guardianship is by state, so if you are moving to a different state, you should talk to a special needs attorney in the new state, talk to them about what the procedure is to get the guardianship recognized. One state will recognize for a period of time somebody else's guardianship. There is a uniform, oh goodness, it's huge acronym, but there is a uniform code where several states belong to, where you could take your guardianship papers and present them to the court, and they will then go through a process to recognize that. New Jersey and New York, which is usually where people move to, in and out of, belongs to both of those. It belongs to this uniform code. But representative payees, I was going to mention, if you're a representative payee, Social Security is federal, so you don't have to worry about that. But guardianship, you really should talk to somebody about it.
And I'm just going to restate the question just for everyone online. There was a question about if you and the individual move out of state, can guardianship, you have to talk to a legal representative in the new state regarding guardianship. There is not special consideration, I don't believe, Gabrielle, you can correct me, if the individual is staying in New Jersey but a guardian lives out of state.
No, guardianship is based on the residence of the individual. So if, sister is now the guardian and she lives in New York, Pennsylvania, or even out in California, it's where the individual lives here in Jersey.
Okay. And then just another quick question. If you go to one attorney when the individual's 3 years old and now the individual's 33, can you go to a different attorney, or do you have to stick with the same?
You can pick any attorney you want. You're not stuck with the same law firm. I would like you to stay with me, but that's okay.
And then some more questions online. You can apply for guardianship at any age as long as they're over 18, correct?
Yes. Yes, so as long as they're over 18, the guardianship statutes apply all the way up to the time they're 98 or whatever.
Okay, and if you're an appointed guardian, do you need to recertify? And this is specifically for a Title IIIB type guardianship.
No, you don't have to recertify. If you've been appointed a guardian, you are a guardian until you go to court, and it's very difficult to get a guardianship overturned. So that's one of the things you have to keep in mind while you have to talk to the doctors. But what you do have to do is file that annual inventory report. Like I said, it's 2 parts. If you're guardian over the person, it talks about whether or not you've taken the individual to a doctor or dentist, whatever, they've had medical care, what they've been up to. You get a certification from a doctor saying that the person still needs a guardianship over their person. The other part is if you're also guardian of the individual, you have to report how much money came in and how much money went out for that individual. And if you look for other services like Social Security and Medicaid and have been keeping that up. So you do have to do the annual reports.
And if you have co-guardians, in the case of divorced parents, do both parents have to fill out the annual report?
Both parents have, if you have co-guardians, whether they're divorced parents or parent and a child, adult sibling, both of them have to sign the report. And a very big suggestion for parents who are divorced, you're going to have to work together on it. Another thing is if you are paying alimony as part of your divorce agreement, talk to your divorce attorney. Alimony is considered income to your individual. So you really shouldn't be paying alimony. You should figure out a different way of making those payments so that they are not counted as income. It doesn't matter if you put them in the ABLE account or whatever. It is income, and that's one of the things that government services look at.
And alimony can be paid into a special needs trust, a first-party special needs trust, correct?
Yes, it can be put into a special needs trust as long as it moves, but it's going to be income until it gets into that trust.
Right.
Okay, and we have some questions about the standby guardianship. Can you have a standby guardian without a specific date of when it will be enacted? Can it just be kind of existing? And does it happen automatically?
Standby guardianship is, you can consider it as the same thing as the power of attorney or healthcare directive. It's effective when it is needed. So it's whenever you go on that vacation, or I had one client who used it. She couldn't go on the 8th grade trip with her child, so the school district accepted the standby guardianship to accompany the child to go on that 8th grade trip. Not saying every district will do that, but that's how flexible it is. So it's always effective.
Okay, and do you need an attorney to designate a standby guardian, or can you have something written up and notarized? You can do it on your own. You can always do pro se, which means represent yourself and not use an attorney. I would say, do your research if you're going to do it, because you want to make sure you do touch the key points to it so that it is recognized, and it does have to be notarized. So that's one of the things that makes it official. Okay, and then the next question regards the will. If a parent puts that they're going to transfer guardianship to another adult child or a sibling for an alternative guardianship, does that automatically happen? Or is there a process that the new alternative guardian has to go through? Okay, so your successor guardian, that's what we call it. Mm-hmm. So in your will, if you name, you're the parent, you name one of your siblings to be the guardian of your child, and this is whether the child is 3 years old or under a guardianship at 33 years old. It will be noted by the surrogates court. It will be processed through the surrogates court. There might be, depending on who's selected, there might be background checks on it to make sure. So that's why a standby guardianship is kind of the Band-Aid or the bridge between when you pass away, your will is probated, and the legal procedures are followed through. Thank you. So those were most of the questions, if not all the questions on guardianship in that regard. So now there's a lot of questions about special needs trusts and ABLE accounts. So the very first question is, what happens to the funds in special needs trusts after an individual passes away?
So in a third-party trust, meaning it's your money that you have planned for. The other thing that the attorney will do in the trust is name what the answer to that question. Who are the remainder beneficiaries? Who do you want to receive the money when you have passed away? And so, or when the individual has passed away. So very often it's siblings first. Has often been charitable organizations. So if somebody is living with an organization that's supporting their loved one, very often they are receive some of the funds. The only time when Medicaid might receive the funds is in a first-party trust. If the money has come directly, a direct inheritance, then the money will go to Medicaid first, and then to what is left goes to the remainder beneficiary. A pooled trust, and one of the features of a pooled trust is that before Medicaid gets paid, the pooled trust may keep a portion of the funds. It could be all of it, but we don't. We keep 50% of a pooled trust sub-account. Instead of paying back Medicaid, that money is available. That funds our pro bono services. We have about 9 Guardian clients who are pro bono. We have a number of clients that we provide this home visit monitoring service to, and we also do a lot of advocacy work. Helping people to access DDD services, to maintain their Medicaid benefits. When somebody has, had a problem and they missed that 10-day window to redetermine Medicaid or SSI, then they might call us for help to, provide the information that's needed to maintain or re-access those benefits.
And I just want to add, with the first-party trust, if there's any money after Medicaid gets paid back, any of that money will go by the state, New Jersey's intestacy statutes. So it would go out through, siblings and then cousins and things like that. So you can't name a beneficiary in a first-party trust after Medicaid. In the third-party trust, as Ellen said, you can name anybody, but generally, if you survive your child, the money goes back to the grantors, meaning whoever created that trust gets it first, and then the beneficiaries after that.
Okay, the next question is, so just for clarification, the special needs trust should be listed as the beneficiary in the will instead of the individual, and you should not use your will to create the special needs trust.
You want to take
Okay.
that?
All right. So yes, in your will, so if you're leaving it to your 2 kids, you're leaving your estate after your partner passes away, and you're the last parent standing, you're going to name your 2 kids. So instead of naming it to, Jack and Jill, you would name it to Jack, who is your neurotypical child, and then instead of Jill, it would be to the Jill's Supplemental Benefits Trust and pay it out that way. When you're putting the name down on insurance policies or other benefit plans, first off, you're going to do a benefit plan or insurance policy, talk to the company in charge, your agent or the representative, to make sure you're doing it and filling it out correctly. But you would name Jill's Supplemental Benefits Trust in order to get the money that way.
Okay. Can a special needs trust be listed as the owner of property?
Yeah.
Yes, it can.
Be. Yes.
And so there was a mention that the attorney must be current with the rules of a special needs trust. Does the special needs trust need to be updated regularly for rule changes?
You should always look at your legal documents to make sure that they're current with the current laws, also reflect what you need. That's why I say you should take it out at least every 3 to 5 years, or when a significant event happens, a birth, a death, a divorce, a marriage, you hit the lottery, you move out of state, you need to really look at your documents. They're living and breathing. You don't do them today and stuff them in the drawer and pull them out 50 years later.
Okay. And then for Plan NJ, is there a cost for drafting and entering into agreement with you today if you're hoping to live another 30 years from now?
No, there's not. If we write an official life plan for you, which tends to be a 25-page document, which documents all of everything about the family. It's about a 3-hour interview, so there is a charge for that, but there doesn't have to be anything. You can just provide us with your documents, and then there is no charge for that.
Okay. And then there's 2 questions regarding ABLE accounts. Can a first-party special needs trust, or can funds from a first-party special needs trust be transferred to an ABLE account?
Yes, they can, up to the $19,000 per year.
Okay, and then can ABLE accounts be transferred from one state's program to a different state's program, or once you create it in one state, it stays there?
Yeah, they are national. You tend not to move the account. You just put the account. Originally, Ohio was one of the first ABLE accounts. It took us a long time to open New Jersey ABLE accounts. And so we would open them in Ohio. They are called stable accounts. So money is national, international. So you tend not to move the account. You just access the account from wherever you live.
Okay. And then the final question was just for clarification. You said that if an individual is on SSI, they can use the special needs trust for food. Is that the same if an individual is on SSDI or supplemental security disability?
Yes, there are far fewer restrictions with a special needs. If somebody is on SSDI, so it's only SSI that has very more restrictive use because it is an income-based benefit.
Right, but if somebody is on SSDI and Medicaid, you still have that $2,000 limit. So you still need to pay attention to that as well.
Okay, I have a question before I turn it to the audience, and I'm kind of afraid to ask, but this is the time to be brave, so I'm going to ask. I got guardianship of my daughter, 15, 20 years ago. I have never been asked to fill out an annual report, and I forgot, so I didn't. So should I go to the county surrogate's office and say I'd like to do it, or should I just kind of wait till they catch up with me?
Okay. Sliding off the lawyer's hat at this moment, it's one parent to another. The annual report is, I don't want to say recent, it's probably been around for about 10 years now. So if you haven't gotten a letter from the court saying that you need to do one, parent to parent,
Okay.
yeah, leave sleeping dogs lie. But I personally use my annual report as my annual diary for my daughter when I fill it out, because I'm required to, because she's only 26 now. But it's, I use it more of, okay, this year she started working, this year she did this or that. So when I'm trying to remember something, I just have to pull out my annual reports.
That's good advice. Thank you.
And you are not alone. Many, many families say, what? I didn't know. Why should I? I'm the parent. Yeah, my suggestion is just start. Just go on the website, the judiciary website, get the document. It's a PDF fillable form, not very complicated to do. Just start to do it. Because there is a voluntary program for the courts to read the documents, but they are starting to read them. I can tell, because we write 40 of them. We're guardian for about 40 people, and a county that has never ever asked us a question recently asked us a question. Oh, okay. How'd you know that? Oh, it was the report. So it's worth it. And then there are a few counties that take it very seriously. Monmouth County, we had a parent who came to us because she wasn't filling it out, and they got a letter threatening to remove the guardianship. I'm not trying to scare you, just saying it's a good idea to do it.
Yeah, and it's to file, it's $5 a page, and that again can come out of your child's account, so if you're looking to spend down. But it's, and I think at most it's like 8 pages. So it's not a bad habit to do. It's something that's useful. And you don't want to get a letter saying, we haven't, especially if you're going to add somebody to the guardianship, you're going to have somebody open up the file and say, oh, we haven't seen an inventory report for 10 years. Can you give us 10 years of inventory reports before we move forward with your petition to add somebody? So it's not bad to do, just to keep up with more paperwork.
Actually, I was going to help respond to your question because I have had this experience. When my mother made myself guardian of my sister, this was back in 2002 with Herbert Henkel, and that was not a requirement. I never had to fill one out, but then I got married to my lovely wife, and she wanted to be guardian as well, and the first thing that was mentioned was, well, you can do this, but you'll have to start filling out the guardianship report because that's now a thing. So we did that, and now every year we have to fill out a guardianship report where for 15 years, didn't even pay attention, didn't know it was a thing.
Thank you. I want to thank Jonathan, Gabrielle, Ellen. You've been very generous with the information, and I appreciate your time. I also wanted to thank Colleen. Where's Colleen? All right, she was here. Colleen McLaughlin, thank you for coming, because the information that you have available to the public at the Bog Center, especially under the tab resources, very, very useful. And I also wanted to thank Paul Aronson and Christine Bachter for coming, because you guys have always provided a clear, strong voice for families. That annual report that you guys produce, absolutely significant, very important. Thank you for coming. Okay, so this morning we heard a lot of information from DDD and from the financial and legal perspective. After a very short break, we are also going to be looking at quality of life, life in the community after you've passed that baton. We're also going to talk about health issues, because that's something that, is going to happen. Your kid is going to get older, and there are things that you should be aware of and options of what you can do when you see these things. We're also going to be talking about housing options, and then we're going to also include ideas for a guidebook, something that you can literally hand over, so all the information that you have accumulated, all the details about your person's life, a real how-to book for your person. That'll also be this afternoon. So thank you very much, and we'll see you in a few minutes.